Hello, this is Henry Quillian. I'm at Taylor English Duma with my colleagues. Though we are doing this virtually, many of us are here together. This is Litigation Fundamentals with Henry Quillian, also known as Quillian's Kernels. We have a special presentation today by Ryan Arnold, one of our newest colleagues, who will be doing a fabulous presentation on the newest Supreme Court decision regarding confirmation and vacation of arbitration awards under the Federal Arbitration Act. We like to remind anybody who's watching these videos that we are not providing you legal advice as a client. If you are a lawyer, you need to do your own research. If you're a non-lawyer and trying to work your way through litigation processes, you need to get a lawyer. And if you don't get a lawyer, you have to somehow become competent yourself if you're legally able to be doing what you're doing in courts or in arbitration proceedings. With that disclaimer, let me introduce Ryan Arnold, who will be talking about the Supreme Court Badgerow case that was decided very recently. Ryan went to UNC undergrad. In contrast to my Duke undergrad, he grew up in Chapel Hill, and then he became a dog show judge for a period of time, where we would love to call him Judge Arnold, but we feel like he might get in trouble on this presentation if we called him Judge on a regular basis. Then he went to UNC Law School, graduated in 2017. He has worked with law firms since then and has a lot of experience. Has been very helpful in many litigations I've been involved with. He is going to be our primary presenter today, and then we'll have question and answers. Well, actually, during the course of it, we can have question and answers from our attending colleagues. And thank you so much for being with us, Ryan. Ryan, please take over.
Thank you, Henry. I'm happy to be here. Just as a housekeeping matter, if anybody has a question, feel free to either raise your hand in the Zoom or put it in the Q&A tab. Either one is fine by me. Like Henry said, I am a litigator. I've been with Taylor English now for about 8 months, and I do litigation. That's my primary focus of my practice, involving both arbitrations and in-court lawsuits. Today, we're here to talk about a case that came down on March 31st, 2022, called Badgerow versus Walters. This is a Supreme Court decision interpreting Section 9 and 10 of the Federal Arbitration Act. Before I go into too much detail on the case, I want to just take a quick step back and set the stage for everybody in terms of the FAA. Section 9 of the FAA is the section which allows a party to seek to have a federal court or a state court confirm an arbitration award. So you've either started out in arbitration or you've started out in court. You've gone through the whole process, you've gotten an award. Now you need a court to enter that award so it has the effect of a final judgment. Section 10 is the opposite. It's if you want to vacate an award. So you think that there was malfeasance in the arbitration, something went wrong, the arbitrator made a mistake, you apply to a state or a federal court under Section 10. This case involved an employment arbitration. The plaintiff in this case was a woman named Denise Badgerow. She worked as a financial advisor in Louisiana, and she got fired. She thought that her firing was unjust, so she instituted an arbitration against her employers, which were a group of people running a firm called REJ Properties. One of them was Greg Walters, who's the named defendant in the case. They went through the arbitration process, and the arbitrator rendered an award in favor of the employer. So Ms. Badgerow lost. Ms. Badgerow, however, did not like that she lost, and she did not take it lying down. What she did next is what gave rise to this case. She turned around and filed a lawsuit in Louisiana State Court against the employers, alleging that they had colluded with the arbitrator and that they had poisoned the proceedings and that the arbitration was not fair. Now, important for this case is the fact that there was no diversity jurisdiction. There was no diversity of citizenship amongst the parties. Diversity means that you have plaintiff and defendants from different states. And that's one of the ways that we get into federal court is if you've got citizens of different states fighting over something and you're fighting over more than $75,000, you can get into federal court. Here, everyone was a citizen of the state of Louisiana. Despite this, the plaintiffs, or not the plaintiffs, the defendants, the employers, removed the case to federal court. So they took the case from state court to federal court and sought to confirm the arbitration award. And they did that based on the Federal Arbitration Act, which, pursuant to the contract they had, governed this arbitration proceeding. The reason that they did that goes back to a decision that the Supreme Court issued in 2009 called Vaden versus Discover Bank. Vaden versus Discover Bank was a decision interpreting Section 4 of the Federal Arbitration Act. Section 4 of the FAA governs motions to compel arbitration and motions to force a party to enter arbitration. Vaden held that in those actions, the federal court can exercise what's called look-through jurisdiction, meaning that the federal court can look through to the allegations of the underlying arbitration. And if those allegations sound in federal law, then the federal court can exercise jurisdiction and can keep the case. Based on that logic, which was at the time the law in the Fifth Circuit where Louisiana is located, the federal court read that same language into sections 9 and 10 because there was both a motion to confirm and then there was a motion to vacate. So both of these were implicated, and exercised jurisdiction and confirmed the arbitration award. Now, this went up to the Fifth Circuit. The Fifth Circuit affirmed the award, affirmed that they had jurisdiction, and affirmed the entry of the award. And then it went up to the Supreme Court. The Supreme Court reversed. And the Supreme Court held that there was no federal subject matter jurisdiction and that the federal court did not have jurisdiction to confirm this award despite the fact that it arose under the FAA. The reason for that is based on textual interpretation and text that is in Section 4 of the FAA and not Sections 9 and Section 10. Before I go any further, I should note for anyone who's curious, this was an 8-1 decision. This was 8 justices in the majority and Justice Breyer in the dissent. His dissent is obviously not binding law, but I'm going to talk about it briefly at the end because, in my opinion, it is Justice Breyer at his most Justice Breyer. It is his view of textual interpretation really summed up in one nice, tidy little paragraph that I'll talk about at the end. But the court determined, Justice Kagan writing for the court, that the difference was this language. Section 4 reads that United States District Court, which save for the arbitration agreement, would have jurisdiction over the controversy between the parties, can rule on a motion under Section 4. That save for the arbitration agreement language is not present in Section 9 and Section 10. So the court held that the court should not read that language into other sections of the FAA. As a general rule, federal courts should assume that when Congress includes or omits language, it's doing so intentionally. And the fact that the save for language is not present in Section 9 and Section 10, the majority reason, was evidence that Congress didn't intend federal courts to be able to exercise look-through jurisdiction. So the next question becomes, where are we? How do you get into federal court to confirm an arbitration award? Justice Kagan and the court hold that you have to have federal subject matter jurisdiction on the face of the application to confirm the award, which she likens to a contract. And under the court's view, action to confirm an arbitration award is simply a state law contract action. There's a contract between two parties. You've reached an agreement to arbitrate. The arbitration has been concluded. You need to confirm that award. That's nothing but a contract action in the court's eyes. Now, that means the only way to get into federal court is to either have diversity of citizenship and an amount in controversy in excess of $75,000, or to have a cause of action that sounds in federal law, which is what we call federal question jurisdiction. These are things like employment discrimination, the Americans with Disabilities Act, Section 1983 claims, which are civil rights claims, things of that nature. The court gives an example of a arbitration confirmation action, which would satisfy diversity jurisdiction, which is pretty easy to imagine. You've got state A versus state B, and then you've got $100,000 at stake. That would get you into federal court. They discuss the idea that you could have an action to confirm an arbitration award that sounds in federal question jurisdiction. They don't, however, provide any examples. And I have been thinking about this case now for a couple of weeks, and I have not been able to come up with any ideas of how you would get an action to confirm or vacate an award that also sounds in federal law without throwing in some sort of unrelated cause of action that would grant federal question jurisdiction. And then you would run into the issue of that really just being there to create jurisdiction, which is another problem that the courts will usually not allow you to do. So that's really this case, and it's a fairly simple opinion. It's only about 15 pages long, and the holding is basically pretty straightforward. If you've got an arbitration and you want to get into federal court, it needs to be diverse in order to confirm or vacate the award. Otherwise, you have to go to state court. And the opinion notes that this paradigm gives the state courts a lot of power and a lot of authority over claims that would otherwise be governed by the Federal Arbitration Act and governed by federal law. And the court sort of throws up its hands and says, that's just how it goes. That's just the way it is because that's the way the statute was written. And when two of the liberals and the Chief Justice endorse this opinion, and one of the liberals actually writes the opinion, that's pretty powerful. That's a pretty powerful indication that textualism is alive and well on the Supreme Court. The text really says what it says. And here it doesn't say that the federal courts can exercise jurisdiction on a look-through basis. Without specific authorization from Congress, the courts are not empowered to create their own jurisdiction. One of the quotes that Justice Kagan uses is, "It's not for this court to employ untethered notions of what might be good public policy to expand our jurisdiction." And that does sort of make sense. We don't want federal courts deciding what comes into court and what doesn't come into court. That should be up to the elected representatives, and that should be up to Congress. Now, the practical effects of this, at first blush, don't seem particularly stunning. It doesn't seem like it's going to be a huge deal. But one of the things to think about is, especially in patent litigation and other IP litigation, if you have an arbitration where one of the remedies you're seeking, one of the remedies you're ultimately granted is a nationwide injunction, and you don't have diversity and you can't get to federal court, how do you effectuate that award? And how do you make sure that you can actually protect your client's rights and protect the rights of your client nationwide without having access to federal court? And that is a question that the Supreme Court leaves unresolved. The Supreme Court basically says, we understand that there are going to be serious practical issues with this decision, but our hands are tied by the text. And the text of the FAA, which has not been updated substantially for some time now, is clear in the minds of 8 of these justices that there is no look-through jurisdiction available. You cannot look to the underlying subject matter, which on a patent case would be enough to get you into federal court. So that is Badgerow. And it is a case that at first I didn't think was going to be particularly consequential. And as I think about it, I think it has pretty significant implications for litigation and for arbitration practice. As we all know, arbitration is favored by the courts. Lawyers have different opinions about arbitration. If you've ever worked with me, you probably know that I really don't like arbitration. I'm a North Carolina lawyer. North Carolina has case law that holds that even if an arbitrator ignores settled substantive law, that is not grounds to overturn an arbitration decision. So this decision sort of furthers that, in my opinion at least, it furthers that favorance of arbitration by removing federal courts from a lot of these questions, especially if you've got employer to employee in a small business context, and you've got an arbitration clause if you've got IP litigation that you're going to have to arbitrate. I think this can be very significant. And if you're not aware of it, then you can potentially spin your wheels in federal court and waste time and waste money before ultimately getting kicked out for lack of subject matter jurisdiction. Because if the court doesn't have subject matter jurisdiction, it can't hear the matter. And even sua sponte, it'll kick you out of court. And I will defer to Henry a little bit on some of the patent and IP implications, since he is our patent lawyer and I do not even play one on television.
So thank you, Ryan. That was a phenomenal overview and think through process. A couple of things do come to mind. One of which you didn't expressly mention, but I think it's implicit in your presentation, is the court also held it did not have jurisdiction to vacate the award, which was the original effort sought by the plaintiff, right?
Correct.
So the plaintiff's been subject to this litigation for years, gotten nowhere, which is something that one of the things we do in Quillian's kernels is try to avoid do-overs and also waste of time, because nothing will make you less popular with your clients than being mired in litigation for years only to get nowhere. But with respect to IP litigation, for instance, I could foresee that you get an arbitration award. Let's say you're the unpopular local company and you have a huge arbitration award in a patent case, or like you say, an injunction against a third party. Well, what if the state court applies more liberal rules than the federal court would for vacation of the arbitration award, and or makes up its own rules, and basically there's a move and an action against a non-diverse other party in the arbitration. You go to state court to get your award confirmed. The other side cross moves to vacate, and you end up with your multi-gazillion dollar award and injunction vacated by the state court judge based on whatever grounds that person could dream up. And then you're stuck for however many years in the state court system, presumably trying to get that vacation of the award reversed. Is that right? The way you could see it playing out?
Yes, absolutely. And the other thing that's interesting about this case, and Charles, I see your question and we'll get to it momentarily. The other thing that's interesting, going back to spending money and unnecessarily spinning the wheels, is that the plaintiff, the employer or employee, Badgerow, arguably did it right. She went to the state court to vacate the award, and then the employer turned around and spun their wheels in federal court all the way up to the Supreme Court, wasting her time, which is an interesting wrinkle and an unfortunate outcome for her, and certainly something that you need to be aware of when you're looking at these sorts of cases.
So go ahead.
I was going to say, Charles McKnight has asked in the Q&A how this decision will affect an international arbitration. I will be upfront. I do not have a wealth of experience dealing with international arbitration. But my read on this case, just from a jurisdictional standpoint, is that it would apply, and there would still have to be some sort of independent basis for jurisdiction. As we all know, it can be very difficult to get diversity jurisdiction over an international entity. So it could potentially close the door, because despite the dicta, I cannot conceive of a way to fashion a complaint to confirm an award without that would also satisfy federal subject matter jurisdiction. And this goes back to a practice pointer for folks on the line, which would be if you have if you have a non-diverse case, you've got an international party, you've got something where you're worried that you won't be able to get into federal court, I think it now makes a lot of sense to file a federal action, stay it, and then move to arbitration. So you have the action there and you have it pending. So you can just go back to federal court, which will still be able to exercise subject matter jurisdiction over that case, and then use that as a shell to confirm the award. And in practice, whenever I can, that's what I prefer to do. I always prefer to file a lawsuit and then stay it, so I've got it there, so I can use that action to confirm or vacate whatever award. But Charles, to your question, I think that's what will have to happen when you have international parties. I think you'll have to have an action filed in federal court that you can use as a vehicle to confirm the award.
And that actually, Ryan's bringing up of filing an action and then staying it before you make the demand for arbitration, or simultaneously, I suppose, is a possibility, or at least maybe one day apart, something I was going to bring up. But we still have to have personal jurisdiction, and that could be one of the problems that you face with an international arbitration award, depending on whether there's some sort of forum selection clause in the contract or in the dispute resolution clause. And I did invite all the corporate lawyers to this because, unfortunately for litigators, the first time we see a lot of the contracts we have to deal with is when they land on our desk long after they've been executed by the parties, and long after the parties have managed somehow to get themselves into a dispute. So I will also hearken back to a previous Quillian's kernels regarding the problems getting non-party evidence under Federal Arbitration Act arbitrations, simply to point out that in that presentation, we point out that there is a need to summon a non-party to an actual arbitration hearing in order to get them to appear and provide documents or evidential testimony, which can be procedurally problematic because you have to open up the hearing momentarily, basically just to get anything in the nature of discovery. And theoretically, it's got to be done at a live hearing, or arbitrators have to be present. But in that instance, the court where you ultimately would seek a remedy if the party does not show is in the district court where the hearing is set, which is actually determined by the rules under which the arbitration is proceeding, or by the stipulation of the parties in the contract. And so that would be different from the actual court you would choose if you did have diversity jurisdiction, if you were to kind of confirm or seek to vacate an award in federal court and you did have diversity. Is that right, Ryan? You would seek, you have to use the normal venue rules for that. Is that right?
Right. And it's important to remember too, one of the takeaways from this case is that the Supreme Court is rejecting the notion of sort of statutory construction and reading these different sections together. They're saying, look, Section 9 is its own entity. Section 10 is its own entity. Section 4 is its own entity. The first thing you do is you read the section. If the section tells you what to do, you are done. If the section is unclear, then you can go to your other tools of statutory interpretation, including looking at what the other sections permit. so you can read them harmoniously. But if it's clear, you don't have to get there. So I think that in that case, because that particular section is clear, the court would say, that's what the FAA tells you to do, you go do it.
And in some instances, I suppose, apparently not in the Federal Arbitration Act, a statute might have a provision that applies to the entirety of the act, in which case it would cover the whole thing. But here it's clearly said in the majority opinion, we can't read from one section, which is on one subject matter, the same rules or jurisdictional rules that are in a different section. Just not permitted. Now, you were going to quote something from the dissenting opinion, which you thought was intriguing.
I was. Before I do that, there's one other practice pointer I want to mention, and this goes back to what is rapidly becoming just a really kind of terrifying quagmire in federal litigation, especially when you're dealing with diversity jurisdiction, and that's limited liability companies. If you've got a party that is a large limited liability company, I'm sure our litigators here probably have heard the horror stories. There's a case that I read out of the Southern District of New York where these folks were litigating over hundreds of millions of dollars for years, nearly a decade, before the federal court said, oh, wait a minute, you've got one member of each LLC from the same state. No subject matter jurisdiction, no diversity, dismiss the case. So if your client is an LLC and is entering into these arbitration agreements, you need to be very, very aware of the membership of all of their members. If it's one person, then it's obviously not as big a deal. But if you've got 100 members, then it's a very, very significant issue. And it's a big trap where you could spend a lot of time litigating a case before finding out that the court didn't have jurisdiction. And also remember that that's an avenue for collateral attack after a judgment, where they can go after your judgment and say you never had jurisdiction to enter it. So that's a practice pointer to be aware of.
And that holds true with respect to members of members. Is that right? So if you had an LLC that's a member of another top level LLC, and then there's a non-diverse owner of that member of the member, that could also defeat jurisdiction.
That's right. They will go down the rabbit hole of LLCs that are members of members of members until they get to the end. And if they find that you've got a plaintiff that's got a member that's a resident of Georgia and a defendant that's got a member that's a resident of Georgia, there is no diversity jurisdiction. And that can be scary.
To clarify this, not to get too far off topic, but it is certainly relevant to this scenario because so many LLCs have arbitration provisions. What is the time at which the assessment is made? Is it the time of the filing of the complaint? Because members of the LLC could change at all times.
Yes, it's the time of the filing of the complaint.
So I guess if you were a defendant, you hated the federal judge or a prospective defendant, and you hated the federal judge in whatever district you were in, trying to avoid federal question jurisdiction, you go out and get a non-diverse member to join your LLC in some minute fraction.
You could try, but that probably, I don't think that would work.
But you might, if you did it before the commencement of the action.
I don't know why. The action, then yes. After the action, then no.
Okay, yeah, because they would probably call it fraudulent joinder of the member or something.
Yep.
But if somebody dies and an heir happens to be non-diverse, I don't see how that would be fraud.
No. And the LLC diversity jurisdiction in LLCs that's setting aside Badgerow and setting aside arbitration. That's just a huge issue in federal litigation generally. It's just always something to be aware of. But the line going to Justice Breyer's dissent, as everyone knows, Justice Breyer is leaving the court and Judge Jackson has already been confirmed to replace him. But Justice Breyer's always been a little bit out there in terms of statutory interpretation and textualism. And I think despite a lot of the rhetoric that flies around surrounding the Supreme Court, everybody starts with the text. And this opinion makes that explicitly clear. You've got, Kagan, Sotomayor, Roberts agreeing with Barrett and Thomas and Alito that you start with the text, and if the text says what it says, you're done. Then you might move on to other tools. But this is the last paragraph of Justice Breyer's dissent, which is almost as long as the majority opinion. Justice Breyer writes, "I suggest that by considering not only the text, but context, structure, history, purpose, and common sense, we would read the statute here in a different way. That way would connect the statute more directly with the area of law and of human life that it concerns, and it would allow the statute and the law to work better and more simply for those whom it was meant to serve." And in a sense, I guess he's right. It would be much easier for all of us if we didn't have to worry about this problem. But the text says what it says. And the majority opinion, the takeaway message, if you read between the lines, is Congress needs to address this issue. And this is a congressional matter. This is not a matter for the courts to rewrite this statute. Justice Breyer comes in and says, yeah, I would basically rewrite the statute by opinion and allow this to happen, which is, it's really just a perfect encapsulation of how he views statutory interpretation, which is read it in a way that gets the result that makes the most common sense, which, as we all know, as people who read law for a living and people who have potentially, worked with congressmen and worked in DC, that's not necessarily how federal law works. So I wanted to point that out because I find that passage to just be it's a perfect encapsulation of of Justice Breyer's judicial philosophy.
So we have a circumstance there where we do have a 100-plus-year-old federal statute, and times have changed dramatically. I'm sure that the FAA, when it was created, probably contemplated transactions involving shipment of military equipment from one state to another, or some sort of major transfer of goods or something between states, whereas now virtually everything seems to have some sort of interstate commerce involved. So the FAA is broader.
The FAA also didn't, I imagine it did not foresee the proliferation of arbitration agreements in the employment context, in the consumer context. If you sign a lease for an apartment, you agree to arbitration. If you buy a cell phone, you agree to arbitration. Arbitration has become ubiquitous in American commerce in a way that it wasn't when the statute was written. And
in fact, a lot of the statutes didn't even exist that are now federal question statutes.
Exactly. And I think that there's a call in this case for Congress to act and Congress to take some action to update the FAA. I'm not going to hold my breath that happens, but I think that that's the message the majority is sending, is you've got a statute here that doesn't really work the way you probably intended it to work. Maybe you need to address that.
So I'd like to open up to the group. Any additional questions you have, we encourage you to raise your hand. We can unmute you if you'd like to ask it in person rather than putting it in the chat, or any observations. It's not just questions. As we know, we learn from each other. One of the goals of this is to get best practices. And here we're obviously trying to avoid a circumstance where we do anything, take the misstep and get mired in some procedural melee that our clients don't want us to be in. So if anybody's got any particular observations, just let us know here, and then we'll close up if we don't have any. I know we have some people that are listening while driving, some people that probably don't have microphones or whatever the case may be. Okay, I'm not seeing any hands going up. Oh, here we go. Well, we do have a great job from John Rezak, and I was about to say the same thing, Ryan. That was excellent. Once again, we've covered a topic of broad interest and serious inquiry that could cause all sorts of heartache for people that are involved in litigation and arbitration. Thank you for being present at Litigation Fundamentals with Henry Quillian. Thanks so much to Ryan for doing a fabulous job. As you can tell, he's a very well thought spectacular young lawyer. Let's keep the good work going at Taylor English. Thank you very much.